Thank you everyone who has joined today afternoon for this session. More importantly, thank you Nish and Rajesh. We all know Nish and Rajesh considering their interest in India, and in fact, Nish and I, work together on several different projects, including the MCIA, the PET project that we work together on, the Mumbai Center of International Arbitration. So Nish is very much a face in India. Rajesh, first of all, congratulations on your appointment of as a Queen's Counsel. I think we are interacting first time after that. So very well done. And again, I think Rajesh and I also worked together on some of the guidelines that we brought about for the Indian Arbitration Forum and some projects and matters that we do together. So thanks a lot, Rajesh, for spending this time with us. He's a Queen's Counsel with one of the very successful chambers, 3VB in London. So his views on this topic would be very helpful. So coming back to the topic and why we chose this topic today, while we are doing, several such client education programs for last 2.5 months since the lockdown started, we thought that while, you know, several legal aspects and provisions that we have discussed, one of the important aspects in any litigation, particularly in India, is to ensure that, you know, you get a decree, you get an award, but that is as good as it gets enforced. And therefore, particularly in India, there is always a need for uh, attachments or injunctions or bank guarantee orders before you even commence the arbitration or a litigation. While it may not be so commonly used in other jurisdictions, as Nish and Rajesh we were discussing earlier, but a lot of these principles actually flow from UK and some of the early decisions on this issue. So we thought it may be a good idea to revisit some of these provisions, particularly in light of the current scenario and the applications which we expect to be, coming up post the lockdown, when things are going to go into disputes for several reasons, including pure stress on economy, disputes related to, breach of performance on services or goods, and also a lot of long-term commitments which people have done over a period of time could not have envisaged such a break in the contractual obligations. So we thought it might be a good idea to revisit some of these provisions, plus look at whether the current scenario will have any impact on how the jurisprudence would develop here on. So with that introduction, I will first go to Rajesh, where he has the experience on the English law jurisprudence on this issue, where Mareva injunctions, as we commonly know, the freezing injunctions, or in India, we even resort to attachment before the judgments under CPC. But it has its own origin in some of the cases early on in the English uh, judgments. So Rajesh, if you can open up the discussions and the topic as to you know what these injunctions are all about, what is the history behind this, and what are the kind of reliefs you can actually seek in situations where you are rushing to courts for such injunctions.
Thanks, Vyapak. Very nice to be on this panel. Hello, everybody. What we call the Mareva Injunction, or in the modern parlance, we say freezing order, as you have. Under English law, it has two main purposes. The first is to restrain a party from removing from the jurisdiction of England and Wales any assets. And the second is to restrain a party from dealing with any assets located in England and Wales or outside that. And it's the second part of those, the worldwide freezing order, that is the most common, but also the most draconian of reliefs that the English court will offer. And it's sometimes referred to in jurisprudence as a nuclear weapon. So it's something that is not granted lightly, but the purpose of it, and I think it would be the same in all jurisdictions relevant to this court, is to preserve the respondent's assets until judgment can be obtained or enforced. And you can get freezing orders before a claim starts, which is the most common type, but also you can apply for them after you have a judgment, if something has changed or you somehow see a pot of assets that you think is then going to be dissipated. You can always go after a judgment or an award. And the context for this inquiry today is really about arbitration, and it's well established in English law that the English court will give you a freezing order in support of an arbitration if certain tests are met. But just in terms of, before I get to the sort of the detail of that, who would you get a freezing order against? The first party is the respondent to your claim, and there are certain tests that you have to meet. There is also a question as to whether you can get it against third parties. Now, as a matter of English law, there is something called the Chabra jurisdiction, and that allows the court to grant an order against a third party who holds assets on behalf of the defendant. So you might not have a substantive cause of action against that party, but if you have good grounds for saying to the court, well, look, there's a third party who seems to hold assets on behalf of the defendant, you should grant a freezing order in relation to that. Now, as things stand, you can't get that Chabra jurisdiction type order in support of an arbitration, because arbitration always is generally a sort of consensual process. But in terms of the origins and scope of what you can get at common law or under English law, it goes as far as that. That's why it's viewed as such a serious measure. And there are various protections that are granted and that have to be dealt with as part of granting an order, because there must be a significant risk of prejudice to you, and the court will usually require what's called a cross undertaking in damages. We sometimes call it the price of the injunction, because it wants to know that if you've gone and persuaded the court to take a route that ultimately turns out to be wrong, that there is scope for compensating anybody who has been affected, the respondent and any third parties affected by the grant of that order. So it's a serious relief. You can try and get it enforced in other jurisdictions. And part of the order, the standard form order in England, is that it does affect third parties who have notice of the order and who can prevent acts or omissions that might breach the order. Now that applies on a jurisdictional basis. So the first, if you get your order in England, that will apply in England. And generally what you then have to do is take your freezing order and go and get it enforced and recognized in various other jurisdictions where you think your respondent has assets. So that really is the essence of that protection. And there will always be exceptions for the respondents, because you can have usual ongoing business expenses, you can have access to money for your legal expenses and living expenses. So it's not intended to completely shut down your opponent's business, because that really would be an abusive use of the court's jurisdiction.
So thanks a lot, Rajesh, for that introduction. And before I come to you for a little more specifics on this, let me get Nish also in here on his experience from Singapore, which is also in a way following a lot of common law principles and the English law principles, which have developed over a period of time, but also have their own way of interpretation. So, Nish, I have two questions for you. One is, what is your experience generally from a Singapore jurisdiction on such orders, and what is the approach of the court? And two, considering you advise a lot of Indian clients on matters related to such disputes, If you can also give your perspective as to how that, what's the difference when an Indian client approaches you versus generally you advise global clients in Singapore?
First of all, great to be on this webinar. Thank you for inviting me. Good afternoon, good evening, good morning, wherever you are. Let me start with the second question first, if I may, Vyapak, because insofar as the principles are concerned and the experience in Singapore, it's largely similar to what it is in the UK. There are some distinctions, but they're not distinctions of substance. So I think let me start with that Indian client question, because it also flows from your opening remarks about injunctions in India. And I thought what might help, particularly those who may be less familiar with the Mareva jurisdiction, is to start from the way that these injunction applications are looked at. Now, when you gave your opening, you said, look, injunctions are common in India. One takes these, makes these applications for injunctions very early in the piece, etc. Now, that isn't the way that it's done in Singapore, and my understanding is that it's not the way that it's done in the UK and in other similar jurisdictions as to that. So for a start, there is a cultural difference in the way that we approach it, and I suspect that's partly because of the way that the time that it takes for matters to get resolved in the Indian context, and an early victory through an injunction may secure the assets so that the assets are available if you ultimately prevail in your case in India. Now, interestingly, one of the principles of Mareva injunction law and injunction law in this context is that you shouldn't use this nuclear weapon, as Rajesh referenced, as a way of securing your claim. That almost seems counterintuitive. Right? So the idea is not you start an action as a claimant or a plaintiff and you try and get security for your claim, because the principle that we operate under is you take your defendant as you find him. So if he is not, and the language used in the cases is, if he is not worth powder and shot, then too bad for you as a plaintiff. So this injunction process, this injunction order that's granted, is not to secure your claim. So that, I think, is the first cultural difference. What it is, therefore, it's there to prevent a recalcitrant defendant or a defendant that is actively seeking to make himself judgment proof. So it's not that he's impecunious to begin with. He has the assets, but he is dissipating those assets so that when you are successful as claimant, those assets won't be available for you to attach. So that's the slight but important distinction between sort of securing assets for the purposes of your claim and securing assets that are otherwise being dissipated. And that's the fundamental principle when it comes to Mareva injunctions. So that's the first part. The second distinction that I thought I should start with is between prohibitory injunctions, and whether you call it a Mareva injunction or a freezing order, and between those two. Now, a prohibitory injunction, as we all know, what it does is prohibits someone from doing something, but the width of that doing something is quite wide. Whereas in the Mareva context, you're focused on asset preservation. The nature of the asset can change, but it's really asset preservation so that you as claimant are not left without recourse at the end of the process. So I think that's the fundamental distinction to bear in mind. Now, when it comes to Indian clients who may not necessarily always appreciate these niceties of law that we are all familiar with, my experience has been, they will come and they will say, okay, when are we going for the injunction? That's almost question number 2 after asking you how much you're going to charge them. So once that question is posed, you have to say, hang on a minute, why do you need the injunction? And then you go, I tend to go through this explanation as to this is not how it works outside of India. The other part of that is you have to go before a tribunal or a court when you seek a Mareva injunction and justify to that tribunal or court that there is a real risk of dissipation. And you can't just merely assert that in an affidavit or a written statement or a witness statement. So you need evidence that that defendant is somehow going to make himself judgment proof. And when you turn up before that tribunal, if you don't have that evidence, you're not going to get that order. So from that perspective, the thinking requires a little bit of adjustment because they may be used to what they, rightly are used to in the Indian context. But I find that most Indian clients are sophisticated. So once you explain it to them, they get it and they understand. Just to give you a sense, in my experience, if I was to do out of 100% of the cases that I do, I'd say in 15% or so of them, maybe even less, we would apply for an injunction of some sort. And of that, probably a much smaller percentage would be in the nature of a Mareva injunction, given how intrusive that injunction is into the activities of the respondent. So that's the Indian client perspective. On the experience in Singapore, it's much the same, as I said, as what Rajesh has pointed out. The principles are the same. You have to show real risk of dissipation of assets, and that's really the cornerstone. There's a balance of convenience exercise that takes place in the same way that it would for other injunctions, but really the nub of it is that real risk. The other final point, and again, Rajesh raised this, is the cross undertaking as to damages. That is a real undertaking that you're giving. And sometimes you need to explain to clients what that means. That means if you go willy-nilly getting an injunction and you're successful and someone is prevented from dealing with his assets in the ordinary course, and that causes loss to that individual, you then have that injunction set aside. There will most likely be an inquiry as to damages. You end up having to pay for that if damage has in fact occurred. So again, that calibration is quite important. Yes, you have that nuclear weapon, but you better decide whether it's needed and whether you push that red button or not. So let me stop there, and I hope I've addressed the
Yeah, sure. No, thanks a lot. That gives a pretty much the ground that we want to broadly cover today. And we'll come to the Indian experience a little later. But coming back to Rajesh, and we all heard that it's a nuclear weapon, it is sparingly used. Courts are obviously very, very reluctant, or I would say they put very high thresholds for granting such injunctions. So all that obviously makes us, think that what kind of matters, what kind of preparations that you need, right? Do you need uh, a good institutional rules to support some of this processes? Do you need proper investigation done on the assets and dissipation right at the start? What kind of evidence that we are talking about? Because it's not only about securing the award yeah, or the judgment, but it is also something which Nish gave a distinction that it is for something which is evidently a dissipation to avoid the judgment rather than you simply securing the judgment which may get. So what are the thresholds? What are the preparations? What kind of evidence you need? Do you just need a good prima facie case and that's good enough? What you need in addition to that? And if you can give little examples where such injunctions were granted based on that, and possibly such injunctions were refused based on that, non-preparation or non-making those contentions or submissions, that would help the participants to understand when they take a decision whether to go for it or not go for it.
Of course. If I start a little bit with the sort of analysis, because the courts test under English law, and I think it is probably similar across the Commonwealth jurisdictions. First, you need to establish that you have a good arguable case. So you'll be saying to the court, this is my claim. And this is why I think I've got a decent argument against this respondent. Then you have to establish that damages are not an adequate remedy, okay? Because if this is only about money, then the court will say, well, why do we need to, take this extra step? And that feeds into the point that Nish made about, well, actually, damage is not an adequate remedy, and this person there's a real risk of them dissipating their assets. So first of all, you've got to indicate that there are some assets somewhere. And then you have to produce the phrase we use now in the courts in England is solid evidence of a real risk of dissipation. And it's not enough just to say, here is a fraud, this is a deceit, there's a breach of trust, there's money has flowed this way. You have to really tie it down. You can't just throw mud. You have to say, well, look, here is the reason. And even the fact that there had been a past dissipation of assets does not necessarily mean now, on the moment you're in front of the court, you can rely purely on that. You need to establish a pattern, and that really, I think, Vyapak is the best area where you would focus on in preparation. I have a concrete example of a case which I can talk about some years ago, and unfortunately, in that case, delay was the real problem, because you have, on the one hand, a need to prepare properly, but on the other hand, you don't want to delay too much, and you will sometimes be going to court on very scanty evidence because you think that money is going to be moving the next day, or a shipment of oil or something is going to be leaving from a port. You've got some intelligence from people who are loading it on or something like that, and you need to freeze that. But you need to prepare an affidavit for the court, a skeleton argument dealing with each of these heads that I've touched on, a draft order which covers these points. The example I was going to give it's a slightly colorful one, but was one I was acted for the state of Iran against a man that they call the Fat Man, who had bribed some Iranian officials in the Ministry of Defense by saying that he was going to be providing a sort of Air Force One equivalent for the Iranian state. And he was producing it via Prince Jaffrey, I think, in Bahrain. And he basically got 3 tranches of totaling over 100 million pounds paid out. And we got forensic accountancy evidence showing that this money, straight after it had got paid into his account, was then siphoned off through casinos in London, through properties in London, and so on and so forth, and large cash transactions as well. And so that's the sort of thing that, it took a bit of time to prepare, because we had to have a forensic accountant dealing with the money flows, which were not just straightforward from A to B to C. We had to have somebody explain, once we had done the internal investigations, where the fraud was. And then the risk of dissipation we were trying to establish on the basis of, well, look, this is an inveterate gambler. Look how quickly the money gets moved around as soon as it comes in. All cases, facts will be different. But you need someone to tell the story, and someone to track the money flows, usually, or the asset flows, and present that to the court. And often you will have someone important to the client, the main client. I think probably Nish will know better, but it's rarer to have the solicitor give the affidavit, because it's not really their stuff. They would only be hearing it from the client. So my preference is always to have a voice from the client. And then if you're having forensic accountancy or so on, then you have someone authoritative, because it's all about presenting this to the court. And we can't lose track of the fact that you will usually be going without notice and on an urgent basis to the court. And in those circumstances, you as counsel are relied on very heavily by the court, because I think the corollary to the point that Nish said, which I agree with in terms of, the number of times you actually go for an injunction versus the number of times you're asked about. I'm advising on them monthly, but we go very rarely. The corollary of that is actually, usually when you go for it, you probably get your injunction. And then there'll be a return date at which the other side will either be coming to create a fuss, or you may have a continuation of the injunction on the basis that they make some promises, undertakings to you and to the court. So there's a heavy pressure on the applicant and their legal team to effectively certify this is urgent. I need to come in front of all these other cases. I need to come in without notice, because usually, certainly the English courts starting point is always you must have a hearing on notice so the other side knows about it. But that may defeat the purpose if you're going for fraud relief in a fraud case or similar, and you're saying there's a real risk of dissipating assets. So the court understands that, and it trusts you, it trusts the advocates, it trusts the legal team behind the advocate. And so that's why you have to be very careful. You will then get the injunction. The cross-undertaking damages, usually you either have to pre-fund, make a payment into court or to a certain account, or otherwise, commercial court usually will take a guarantee on a first-class bank, is the phrase that they use. But you need to tell your client that this is a very real thing. You can't just say, I promise I'm good for the money. The court will expect a little bit more than that. But so in terms of the focuses, it's really on getting good evidence and being able to persuade the court that they can trust you.
Sure. Thanks a lot. And Nish, from perspective of going to courts versus going to the arbitral tribunals, and now the new way of getting urgent reliefs, which is the emergency arbitrators, uh, which is also very common when it comes to Indian clients and Singapore-seated arbitrations and even some other places. What is your experience? Do you think the tribunals have pretty much, or the emergency arbitrator has pretty much the same powers as a court would have, or necessarily you need court's intervention in this kind of injunctions because these are wide and vast and beyond the contractual realm of an arbitrator granting some injunction or prohibitory orders? Uh, what do you advise? And have you seen any jurisprudence as to whether this two uh, jurisdictions, one is the arbitration and the court jurisdiction, they somewhere merge when it comes to this kind of injunctions, or they are totally distinct and there is no alternative to courts?
Sure. I think to best answer that question, I'll go back a little bit in history and see how this is developed in terms of arbitration law. Now, the starting point is an arbitral tribunal in Singapore has the same power to make an award that a high court judge does. So that's your starting point. So in terms of the powers that a tribunal has, they're the same, right? In legal theory. I'll come to the distinctions in the context of Mareva in just a second. So the way we would describe that is concurrent jurisdiction. Right? And back in the day, you had the ability to choose which one you would go for. There wasn't a sort of preference given to one over the other. So you could start and say, I'm going to go in for interim relief. And interim to what? Interim to the constitution of the tribunal, which might take 3 months or whatever, right? So you have that ability. Now, the arbitration community sort of realized that by doing so, you were infusing a litigation element to what should otherwise be an arbitration process, a consensual arbitration process. So the concept of an emergency arbitrator was introduced into the arbitration world. Most institutional rules today provide for that. Some jurisdictions have made express amendments to their legislation to recognize and give status to that emergency arbitrator. So again, if one steps back, does the power exist to grant relief such as a Mareva injunction? The answer is yes. In the concurrent jurisdiction realm, the change that has occurred is what Rajesh opened with in terms of when should you go to court and when should you go to the arbitral tribunal. In sum, if the tribunal is formed or is capable of being formed, then you shouldn't be running to court because you have consensually chosen a different process, a different dispute resolution process. And that's the same in Singapore. So the court will ask you, if you turn up and say concurrent jurisdiction, Why have you not gone to the tribunal? Why have you not constituted a tribunal? Because really, this isn't the realm of the jurisdiction of the arbitration tribunal. So you need to have a very good answer for that. Now, I'll add to that, in terms of timing for the appointment of an emergency arbitrator, again, depending on the rules and so on, it's a very quick process, right? Again, depending on the institution, it could be within 24 hours or 48 hours. We're talking about that sort of window. And it's not dissimilar to going to a court and seeking an urgent hearing. If you're lucky, you might get a hearing in the course of the day if the judge feels that it's urgent enough. But it's not unusual to have that hearing the next day, for example, if the judge's diary cannot accommodate it. So from a timing perspective, there isn't a lot to differentiate between an EA, an emergency arbitrator, and a court hearing this injunction application. So what then is a circumstance where you would go to court and seek an injunction of this nature when you have the opportunity to go to arbitral tribunal? I think what you will have to show, as I said, is that the tribunal is somehow unable to provide the relief that you're seeking because of some peculiarity. One of the most often peculiarities is this. As Rajesh says, the broad principle these days is one of notice, even in court, when you seek a Mareva injunction, okay, or an injunction of that sort. If for some reason you feel that giving notice will defeat the Mareva because money can now go global, it can be transferred out in a matter of seconds. That's one example. Giving that notice will defeat the purpose. That's one ground on which the court may say, okay, I understand. You should be giving notice, but you can't for this reason. But you will undertake to give notice as quickly as possible once I grant you the order. That's the way that will be played out in court. Now, one of the peculiarities of arbitration, as we all know, is that you have to commence that arbitration process. And almost by definition, that notice will be given to the other side. And the question of whether an emergency arbitrator can hear an ex parte application, we know the answer to that. So in that scenario, that concurrent jurisdiction kicks in where you say, actually, it's better to go to court because I can do it on an ex parte basis, get my order. There may be a return date, which is done on an inter partes basis, but at least I have that as an option. So I think that's really the distinction between the two.
Sure. Thanks a lot, Nish. So while we understand now the global perspective, I think India is not far behind. In fact, so far as injunctions are concerned, I think we have seen it granted practically overnight, not even next day, when it comes to such urgency. And I think at least the judges and the jurisprudence in India is pretty much, developed in that context. So may I bring Shweta here to give a little bit of an Indian perspective? Uh, and Shweta, do you see anything different in India as far as the principles are concerned? Do you think the thresholds are lower as because of the cultural differences, as Nish was pointing out, or ultimately the grant is based on similar high thresholds? And if you can give an example or two as to when such injunctions were granted or refused, that would be helpful.
Sure, Vyapak. Thank you so much for the question. So before I get into the threshold, let me just give a very brief background as to where do the Indian courts derive this power from. Now, there's a divided opinion over here because some of the Indian courts, especially the Delhi courts, for example, they kind of believe that this is similar to attachment before judgment. So the conditions that are required for granting attachment before judgment would be applicable in case of Mareva injunctions as well. However, a few other courts say, they should not be treated so. They are two different concepts. the CPC, the Civil Procedure Code of India, deals with attachment before judgment and injunction separately under different provisions. So the test would not be the same in case of Mareva injunctions as in case of attachment before judgment. So there's a little bit of confusion over there as to the thresholds over here. Since we've already dealt with the broad test required for injunctions, I'll briefly touch upon the test for attachment before judgment in India. Whether there is an intent to obstruct or delay the execution of a decree or an award in case of an arbitration, and there's an intent to dispose the whole or part of the property or remove whole or part of the property outside the jurisdiction of the court. Now, in case of Mareva injunctions and attachment before judgment, courts have tried to show a little difference over here. For example, in case of Mareva injunctions, a mere risk of dissipation of assets would be substantial, which would be okay with it. And they don't have to really show that there was an attempt or overt act by the defendant to dispose of the property outside the jurisdiction of the court, or there was an intent to oppose or defeat the purpose of the award or judgment. So only a risk of dissipation of assets would be sufficient. So this is the threshold is a little lower, and which could also be subjected to misuse and abuse. So over here, I would like to go ahead and narrate a few incidents where courts have tried to counter the misuse and abuse of Mareva injunctions. For example, like we have already discussed, in India, it's a kind of a habit, to first apply for injunction in a matter that is coming in. So courts have tried to say that, merely because a suit was filed or initiated or has been initiated, that doesn't make a good enough case for granting of Mareva injunctions. So that is something which courts have started to observe. And also they have started to put in conditions while granting Mareva injunctions. For example, the Delhi High Court in a very recent case was of the view that, okay, fine, we'll grant the Mareva injunction, but the plaintiff has to give an undertaking that it would compensate if subsequently it is found that the injunction was not really required and the purpose of the injunction was not served because there was no actual case of dissipation of assets or intent to do so. So that is where the courts are trying to strike a balance, but the threshold is kind of a little lower if we compare with other jurisdictions. So broadly, it's more or less in. Now, in another recent judgment of the Delhi High Court, the respondent company was owned by the Russian government. Now, because the company was owned by the Russian government, it was very difficult to establish or show that there was an intent to defeat the award or the judgment, and then there was a fraud being done for dissipation of assets. So here the court wasn't agreeable to granting a Mareva injunction because it was a government-owned entity. So this is where India stands and the thresholds are in India.
Sure. Thanks a lot. And taking the example of the Russian government entity case, the Rights Approach Group, that was, I think, in the context of an foreign seated arbitration between two, non-Indian parties. So, Alipak, if I can bring you in on a couple of questions, particularly, bringing the aspects of arbitrations and going for such freezing orders pending the arbitrations. Can you give the perspective as to what has changed post the Balco judgment, particularly as to when you can approach in Section 9 pending the arbitrations, in aid of arbitrations, versus going to court as a original suit for some of these injunctive reliefs versus going, in the aid of arbitration. To with the amendments in 2015, even in India, as Nish was saying, it's almost like a concurrent jurisdiction. Earlier, there was a very strong argument that why you are rushing to the court, because Section 9, which allows courts to grant much wider prayers or wider reliefs, Section 17 is very restrictive for the tribunal to grant certain prayers, particularly, obviously, they still can't give prayers against third parties or without notice, but at least in terms of the jurisdiction or powers to grant, reliefs, it was very different. So that position has also changed post 2015. And now you can even approach a Section 9 court or go to 17 if tribunal is formed. And of course, the amendment allowed approaching Section 9 courts even for a foreign seated arbitration, which was not the case, uh, pre 2015 amendment and post Balco judgment. So, what does all of this mean in terms of freezing orders? What's the experience of India, and what are the issues that you see in that jurisprudence going forward, knowing how the law is changing?
Thank you for that, Vyapak. I think before I start, I think you rightly mentioned, while India is known for delay in the judicial process, but it acts really fast in terms of grant of injunctions. You could get it in less than in 24 hours or 48 hours. I mean, courts are really quick. You move a Section 9 application, it gets listed the very next day. So we are in a jurisdiction where, I mean, the courts are known for granting such injunctions. Now, the threshold for grant of injunctions and all that jurisprudence, I think Shweta has already covered. I wish to trace it back to pre-Balco judgment. What was the position? I think at that point in time, one was to avail a relief interim protection under Section 9. The judgment of the Supreme Court's judgment in Sundaram Finance, that prevailed. The only threshold one had to show was the intention to arbitrate. Now, this is besides the regular threshold which you will show for grant of injunction, such as prima facie case, balance of convenience, irreparable harm. That comes out of common law principles. So that is constant. But as regards specifically for an arbitration, in aid of arbitration, the limited threshold was to show that you had the intention to arbitrate. Now, that resulted in parties availing a Section 9 order and sitting on it for years, months and years, without actually invoking the arbitration. And once these orders were granted, it would be very difficult for a court to sort of vacate the orders. I mean, generally courts are very reluctant to vacate interim orders. I mean, there are provisions to do it, but in practice, it is very difficult. Now, then came the 2012 Balco judgment, which sort of had set India in the international arbitration framework. The Balco judgment said that Part 1 of the Arbitration Act, which contains Section 9 and Section 17, which is what we are discussing today, is only applicable for India-seated arbitration. Well, Balco judgment was celebrated all over, but this is the limited aspect which was criticized, that it sort of restricted the parties to a foreign-seated arbitration from approaching the Indian court to take an interim relief. Now, this was subsequently discussed and debated. All of us, we wrote a lot of articles. In 2015, amendments were brought into the Arbitration Act, where they have included a proviso saying that Section 9, as well as there are two other sections, which have been made a standalone provision, meaning that irrespective of where your arbitration is seated, you could come before the Indian courts and seek interim protection. Now, that has been sort of the game changer. Now, along with that, there are 2 or 3 other amendments which I would like to discuss. In Section 9, it has now been specifically provided that the interim order granted by the High Court will stand vacated within 90 days unless you invoke the arbitration. Of course, there is a limited window where one can approach the High Court and seek an extension of that order. But the law is that after you seek the Section 9 interim order, within 90 days, it is mandatory for you to invoke arbitration. Now, another point connected with this, for the benefit of audience, the way the interim order works is it can be obtained before filing the arbitration, it can be obtained during the course of arbitral proceedings, as well as after the award has been passed, but prior to enforcement of such orders. So it contemplates 3 scenarios. At least the first scenario, the amendment makes it very clear that within 90 days one has to invoke. The second aspect which the amendment clarifies is that previously the power of a court under Section 9 was much wider than what a tribunal could do under Section 17. And this has been a bone of contention. In fact, Vyapak and I, we did a case where bank guarantee was granted under Section 9, and then bank guarantee was sought under Section 9. Subsequently, the Section 9 petition was converted to a Section 17 petition, and the tribunal had to be approached. The tribunal refused to grant the bank guarantee, and then the matter went to Supreme Court. Now, post-amendment, the powers have been made similar to what Nish was saying. The position of law in Singapore is that there exists no difference between the power under Section 9 and 17, save and except the limited part that orders against third parties. Now, the legislation does not distinguish. The legislation says that similar powers are there, but we have had cases against third parties, orders against third parties in Section 9. Similar such examples have not yet happened under Section 17. Now, the other last point which I would like to touch upon is a very interesting case of Raffles Designs versus Educom Professional. This was a Singapore seated arbitration. An emergency arbitration award was obtained in Singapore. Subsequently, that order was sought to be enforced in Singapore as well against certain Singaporean defendants. Interestingly, instead of filing an enforcement petition in India, the plaintiffs filed a Section 9 petition before the Delhi High Court. Now, there were a lot of other issues, whether the amendment, the provisions of the amendment will apply to this case or not. But broadly, the High Court took the view that in view of the amendment, the fact that the Section 9 has been widened to include a foreign seat of arbitration as well, the grant of relief under Section 9 could be allowed. So this is one way, while there is a lot of debate and confusion as to the status of this emergency awards in India, because unless an award is final to that extent, under the enforcement regime in India, there are difficulties in enforcement. This is a case where under Section 9, one party tried cashing on the emergency award and seeking relief before the Delhi High Court, and the High Court granted such relief. That is where I would like to end for this.
Sure. So thanks a lot, Alipak, on the background and how India is, shaping up its provisions around this injunctions. I think even from a cultural perspective, Nish, we are seeing some difference now, or I would say we are aligning with the foreign culture for 2-3 reasons. One, of course, the time taken for the arbitration proceedings itself have reduced drastically. Where people used to talk about few years, now they talk about couple of years. So there is a difference in the expectations by when you will get your final award. And two, I think courts have also more and more taking a little bit of a hands-off approach. While it is in support of arbitration, they try and push things to arbitration rather than grant injunction here and there to make things difficult for either party to actually go for the merit hearing, or make that redundant in light of the injunctions already granted, where the plaintiff would then try and rather than respondent delaying it. So I think things are changing. The thresholds are obviously theoretically same, but practically are now getting similar as the foreign jurisdictions. But of course, we are only learning from how the other jurisdictions are, uh, dealing with this issue. So while we have discussed this topic purely from a claimant perspective, right, throughout, I think there is another side of the story, which is the defendant in every case. And there is always a perspective from the defendant side for resisting such injunctions or overturning it. What's the kind of uh, you know thresholds you have seen for resisting such injunctions or overturning it? Maybe Rajesh can start, and then Nish, you can give your thoughts on that from a defendant's perspective.
Sure, Vyapak. I mean, I think often you have to gauge as a respondent whether it's worth fighting about this upfront battle, the procedural effect of a freezing order, or whether you can give an undertaking, say, listen, I'll promise not to deal with this pot of cash or this asset, and I don't think there's anything to your claim, but we'll fight it down the line in the proper way. So there'll be that strategic battle, because as I said, it'd be very expensive just to go into return dates and inter partes hearings and to fight. But if your client is minded to, or if there are egregious cases, I think the usual key battlegrounds are often on material non-disclosure, whereby you say to the court or the tribunal, look, this shouldn't have been granted because they didn't tell you A, B, and C. And I had a case in the DIFC where a freezing order had been granted over the assets of one of my clients, and based on an arbitration award made with the New Delhi seat, which is the subject of an appeal in Delhi and Mumbai. And they'd gone off to the DIFC and just had not told the DIFC anything about the reality of the nature of the case, the fact that there was an appeal, the fact that monies had been paid into court in India. So we prepared an application saying that these are all the grounds they've got it wrong. The Indian law is wrongly presented, the procedure is wrongly presented, the strength of their case is wrongly presented. These are all material non-disclosures. So that is one of the sort of main areas. It's pretty hard once the injunction has been granted. It's quite hard to try and deal on a summary basis whether there's a good arguable case or not. That ship has probably sailed, and you're best off saying we deny the allegations. This relief is not needed. It's over the top. Here is this money. So, or otherwise you attack the non-disclosure points.
Sure. Nish, any different approach that you would advise an Indian defendant?
No, I think Rajesh has hit the nail on the head. Really, if you come back on the return date, so injunction's been granted, come back on the return date, what are you going to be saying to the court, right? I think you're limited to either saying it's an abuse and therefore it should be dismissed, and the abuse would be things along the lines of failure to provide full and frank disclosure. They've come in ex parte, they didn't tell you what they ought to have told you, and had they done that, the court would not have granted the order that it did. So that's one. The other bit of it is really what Rajesh touched on in terms of undertaking. Really what you're saying to the court there is, it's been presented as if, our client, the respondent, is seeking to frustrate the judgment, seeking to make himself judgment proof. Absolutely not. Here it is. Here is something that will give the court the comfort that that isn't the case. And I think that will go a long way towards assuaging any concerns that the court has as to the need for an injunction to protect the assets. If you go back to the starting point where I said, look, an injunction isn't supposed to be there to secure the claim, that's where if you're able to demonstrate that actually this was really them trying to put pressure rather than truly believing that an injunction was necessary, I think that's where you're likely to get the greatest traction.
Thanks a lot. We are coming to close to 1 hour, but we have a couple of questions, and they are in a common theme. So maybe I'll ask the same question to you, Nish and Rajesh, and maybe this time we can start with Nish and then end with Rajesh. So basically, I think the questions are in the context of foreign proceedings and going to courts in Singapore or English courts, as the case may be, while the proceedings are not in Singapore and not in London, respectively. And two, if third parties are involved, how often courts are, granting such reliefs. So if you can give a minute or two on that, and also if you have any general comment on the session, particularly in the current situation, whether this kind of reliefs are going to be more popular, or courts are going to be more reluctant, considering there is a downturn already and there is reason to not grant such reliefs because people are going to face troubles in paying. So your thoughts on that? So if you can touch both of that, and then we can go to Rajesh.
So starting with injunctions in aid of foreign proceedings. Interestingly, Singapore went through a little bit of a shift in position insofar as that's concerned. There were two cases in Singapore. One was Swift Fortune, and the other was Front Carriers, taking diametrically opposed positions. High Court cases.
Which is not very common in Singapore, right?
Yeah. So it's about 2007, the power to grant injunctions in aid of foreign arbitrations. The other said no. Interestingly, the matter went before the Court of Appeal, and the Court of Appeal decided and said, no, you can't grant a Mareva in aid of foreign proceedings. And in the Swift Fortune case, and now this all sounds rather dated, but a quote from the judgment effectively said that that would be contrary to the spirit of international arbitration. But what then happened was the legislation was amended to make it crystal clear that that the sections under our Arbitration Act that give the power to grant such relief can be invoked irrespective of where the place of arbitration is. So in a nutshell, yes, you can in aid of foreign proceedings. Third parties, slightly trickier. Obviously, the tribunal it's a consensual process, so the tribunal has power over the parties that have given the tribunal jurisdiction. Whereas in the court, your powers are far greater so long as the court has jurisdiction over an individual or a corporate using the principles that we would typically apply for that court to establish jurisdiction, then orders can be made as against that party, including third parties to an action. So in that sense, the court's powers are wider than the powers of the arbitral tribunal. And finally, in terms of the current COVID situation, do I expect there to be more such applications? I guess the starting point is I expect there to be more stress and distress in the market. And stress and distress typically leads to disputes, and disputes lead to people not necessarily wanting to satisfy judgments. Circumstances may have been such that they've been forced into a particular position under a contract, and they're facing a huge claim. So the answer is yes, I do expect there to be more cases where such injunctions will be sought. At the same time, you asked whether courts are going to be sympathetic. I think what we've seen around the world is a view amongst governments that this is something that we're all in together. Right? This is not something that's been created by an individual or a group of companies or whatever. This is a pandemic. The situation is dire, and lots of people who are very honest, normal business people are going to see stress and distress. To that end, a lot of governments have introduced moratoria, so you can't enforce as quickly as you otherwise could in certain countries, including Singapore. So I think there will be a fair bit of sympathy for defendants in this period, but that's not to say that the law will be put aside. Of course not, right? Judges are there to do justice and the law, and they will abide by the law. But when you're in the margins, when you're having to make a call on whether you should put financial pressure, and that's what a Mareva injunction will do, financial pressure on a particular corporate and an individual, I think judges, being human beings, will not divorce these thoughts from the way that they decide.
Sure. Rajesh, your final thoughts on this? We are almost close to 4 p.m., so we'll close with your final thoughts.
Thanks, Vyapak. Sorry. Like with Singapore, the English court will grant relief if the arbitration is seated abroad. but there are various sort of connecting factor tests that you would need to meet and to persuade the court that it's appropriate. And generally, it's about practicalities and the need to ensure the effectiveness of whatever judicial or arbitral procedure is going on. That feeds into what Nish has been saying throughout about why you give an injunction and why why you're given a Mareva injunction. Because you've just got to ensure that the procedure is effective. And if someone can dissipate assets, that's effectively abusing it and undermining the process. As a matter of English law, most recently, I talked about the Chadra jurisdiction, about freezing orders that affect third parties. There is a case from 2020, Transoil International and Savoy Trading, where Mrs. Justice Mulder has said that freezing injunction relief under Section 44 and permission to serve out cannot be granted against non-parties to an arbitration agreement. So that's a new development which is the subject of some academic and practitioner criticism, but that's a current position in this arbitration context. Finally, in relation to the effect of COVID-19 on this sort of application, look, the approach of the courts in England is very much to try and say it's business as usual. Nish is obviously right to say that you have all of these insolvency in particular measures and moratoria that are coming into play, and English law is also has a sort of protocol in relation to that. I think what I'd say is that the courts will take each application on its merits, and if there are good points to be made as to why the relief shouldn't be granted, or otherwise, remember on full and frank, you have to raise the points against you if you come to the court without notice. So you should probably be having in mind not only what the legal defenses might be, but any sort of practicalities that the other side might raise if they had been there, because that's one of the things the court expects from you as part of the full and frank disclosure process.
Sure.
But otherwise, no, nothing further to add.
Sure. Thanks a lot. I think there are a couple of more questions, but that's okay. I think we'll respond to them separately. And thanks again, Nish and Rajesh, to join us for this session. We really appreciate your time. And since now we are able to record every conversation and all the webinars, all of this will be available for future reference as well. So that's a contribution possibly we would make to the jurisprudence as it develops in this regard. So thanks a lot.